Good morning, Secretary Johnson.
Amy, thanks for having me. Looking
Thanks
forward
so
to our
much for
discussion.
joining us. So for those new to Her Justice, we're a not-for-profit that stands with women living in poverty in New York City. And we stand with them by training and mentoring volunteer lawyers from across the city to address their individual legal needs as well as systemic challenges they might face. We have what we call a pro bono first model. And what that means is that most of the legal representation that we provide to our clients is coming from these hundreds of private attorneys who we mentor and train in the substantive areas of law, family, divorce, and immigration, which are the areas in which we practice. That allows us to take a 17-person legal department, harness the contribution of hundreds of attorneys, and therefore help over 4,000 women every year. So we've invited Secretary Johnson to speak with us today about a report that he submitted to Chief Judge Janet DiFiore last month regarding racial bias in the New York State court system. And for those of you who haven't yet read the report, I highly recommend it. You can get a lot out of the executive summary at the front of the report. And in his investigation, Secretary Johnson found many dedicated members of the court community. Many of them are familiar with those members, but he also found many areas demanding urgent attention. The executive summary outlines a comprehensive list of recommendations for reform, ranging from expanding bias training, strengthening and promoting existing resources for the reporting of bias, continuing progress in the provision of translation and interpretation services, to improving data collection and facilitating the navigation of courthouses. So it's a really expansive list of recommendations that the courts can start to undertake right away. So there are many observations in the report about the ways in which racial bias show up in the court system. But the observation that to me summarized the overall impression that the report left on me, at least, is the recognition by many of the people interviewed by Secretary Johnson and his team that an under-resourced or overburdened New York State court system has a dehumanizing effect on litigants, and it has a disparate impact on the people of color who navigate that system. And for us, that was really critically important at Her Justice because over 2/3 of our clients are navigating that exact system in family and supreme civil courts, and 90% of our clients are women of color. So this is the system that they enter with us. So Secretary Johnson, again, thank you so much for joining us today and what I know is a very busy time for you. I just want to reiterate, and ask you, you were asked by Chief Judge Janet DiFiore to conduct this review in June of this year. And just to remind everybody, since we're all kind of milling about in COVID time in our heads, in June in New York City, we were just coming out of what was some of the worst moments of COVID we had experienced in our city. We were starting to see come out a little bit from the most severe COVID lockdown that we had experienced. We had also, of course, just witnessed the horrific murder of George Floyd. Black Lives Matter protests were on the rise, and the public was raising real questions about fundamental questions about the legitimacy of the rule of law. So at that moment, the Chief Judge comes to you and asks you to take on a review of racial bias in the New York State court system. What went through your head when she asked you to take on this assignment?
Wow, it's quite a question. Let me do my best. First of all, Amy, thanks for having me. And I want to acknowledge and applaud all the terrific work of Her Justice. It's remarkable. It's only 17 lawyers, but you are also in a position to funnel and recommend lawyers at larger firms to help with this. One of the values, by the way, of organizations like yours is not only are you servicing the poor, those most in need, but you're also introducing younger attorneys at large law firms to potential careers in public interest law. Very often associates at Paul Weiss come to me and ask me, how can I become involved in public interest law? How can I find a career there? And very often I tell them to find ways to work with organizations like yours to introduce themselves to your world. So not only are you doing great things for your clients, but you're also doing great things for career development for a lot of younger lawyers who want to serve the public interest. So Janet DiFiore called me on June 8th, 2020. It was a cold call. And there was a lot going through my mind at that moment. I have been a lawyer for 36, 37 years now. As a matter of fact, I started at Paul Weiss exactly 36 years ago yesterday, November 12th, 1984.
Happy anniversary.
And I have, for the most part, throughout my professional life and professional career, been less than comfortable talking about matters of race. In public commentary while I was in office, I have not, you will not find a whole lot from me on issues of race. I haven't been entirely comfortable with it because it's such an emotional subject. And my feelings about matters of race are complex. June 8th was a little more than a week after George Floyd was killed. And I was being asked for public commentary about George Floyd, CNN, MSNBC, elsewhere. And I struggled to figure out what my voice was going to be through this whole crisis. My first TV appearance after Floyd, I'd consulted a very, very good friend of mine who was a retired New York City police officer. He's a cop's cop. And he kind of put in my head the law enforcement commentary about George Floyd. Well, we don't really know what happened yet. We don't know all the facts yet. And I said that. And I as part of a bunch of things. And I got some pretty angry responses to that. We do know what happened. He was murdered. And so I said, okay, that was my first time out of the gate on this issue. I need to do better. So June 8th, as I recall, was a Monday. I was due to have an interview with Fareed Zakaria on Sunday, CNN, which was, I think, June 7th. And I, on Saturday, had a Zoom conference like this with 6 fellow graduates of Morehouse College. Morehouse College is an all-male, all-Black school in Atlanta, Georgia. The most famous alumnus of Morehouse College is Martin Luther King. I had a conversation with 6 Black men from Morehouse College. It was like going to the barber shop on Saturday morning to talk about George Floyd. And there were 2 of my first cousins who went to Morehouse, several of my classmates, and I found my voice in that conversation and was comfortable talking about race the next day with Fareed Zakaria. Following day, Judge DiFiore calls me and asked me to take on this assignment. Had she asked me a month before, I probably would have said no. But she asked me, I thought about it. I was going to say no. I was sitting there listening to her on the phone. And then something made me change my mind to say yes. And I said, I'm going to need a lot of help, Judge. I'm very busy. Can I be the chair of a commission of a bunch of judges? And, we'll schedule the meetings and I'll preside. And she said, no, actually, I'd like you to do it all by yourself. I said, okay, I'll rely on my associates to do this. And so off we went. One of the remarkable things about, and one of the reasons I said yes was at that point, I felt as though I knew my voice. I knew what my thoughts were about George Floyd at that point. I should mention, and this is not public, that on the very same day, I got the call from Chief Judge DiFiore. I got a call from the Secretary of the Army, who asked me if I would chair a commission on renaming Army bases in the South to take the names of Confederate generals off all these bases. And I said, Ryan, I think I'm going to stay away from that one. I took the easier assignment, which was Chief Judge DiFiore's assignment. So, and I'm glad I did.
We're all glad you did, Secretary. Well, thank you for that story. That's really powerful because coming to terms with how one talks about race is complicated. It's really interesting to hear how you got there. And I will say that having read the report, obviously, in your introduction, you really feel your voice, particularly in the introduction, and that's in part what made it so powerful for me. As
there's
official document.
A story to that too. 10 years ago, along with General Carter Ham, when I was General Counsel of DOD, he and I issued a report on whether or not the military can handle the repeal of Don't Ask, Don't Tell. It was exactly 10 years ago this month. And I know from experience, 95% of the people who read a report only read the executive summary. So it's important to give the entire account just in the executive summary.
Yeah, absolutely. Yes, those are things we learn in our professions, and you're absolutely right. So just as you were saying, you were coming to terms with your own voice, and I really think that comes across, especially in the executive summary in the report. The courts that you were investigating are not courts necessarily in which you personally have appeared, I would imagine, in your career. And that's true for a lot of the attorneys, as you mentioned earlier, that we mentor and volunteer. Most of our lawyers, when we work with lawyers from law firms, when they go into family court with one of our clients, it's going to be the first time they've ever set foot in a state court, much less a family court. And many tell us that no matter how well they prepare the case, and they prepare it very well, the law, the facts, et cetera, they are surprised by the experience of their first court appearance in family court. And so I wonder for you, as you were working with your colleagues at Paul Weiss, what most surprised you as you were conducting this investigation?
Well, yes, you're correct. It's not like appearing in commercial division of New York County Supreme. From 2001 to 2004, I chaired the Judiciary Committee of the New York City Bar Association, which rates and approves every judge, every candidate for a judgeship in New York City. In 3 years, I interviewed 500 people for judgeships, including U.S. Court of Appeals, Second Circuit, U.S. District Court, Eastern and Southern District, New York Court of Appeals, Appellate Division, Appellate Terms, Supreme Court, New York County, all 5 boroughs, Housing Court, Family Court, Criminal Court, Civil Court, and the DAs and U.S. attorneys. It's a lot of people, and I learned a lot about the court system just from that experience. And so by the time I got to do this report, I knew what I didn't know. And I'm not a practitioner in family court. I'm not a practitioner in criminal court or civil court, like people who are there every single day. I know, for example, from my experience on the Judiciary Committee, there's a sharp divergence of viewpoints among lawyers who appear in housing court. There's the landlord's bar and the tenant's bar, and the world is round, the world is flat. And so I knew what I didn't know, which therefore meant that there were certain areas I knew not to tread into, like the substance of decision making, or a lot of criminal defense lawyers urged that I recommend we lower the bar for Batson challenges, for example.
Right.
And I knew that there were probably some really good countervailing arguments that I was not privy to. So there are certain places I stayed away from and left it to others to sort out. And I got the clear impression from Judge DiFiore that there were certain things she did want me to get into, like whether or not there should be a social media policy for the court system's bureaucracy, and certain places that I should stay away from because it was going to be a slippery slope. And once I got into the substantive decision making, I knew that I'd have to try to touch bases in every single court. I had 10 terrific associates helping me with this. They were highly dedicated. They too, of course, did not practice every day in these courts. They were tempted to get drawn into a lot of people. We talked to a lot of organizations were really passionate about their mission, and they were passionate about their clients. And my associates would be drawn into their passion, and they'd want to recommend that we do something to address the concerns of a certain part of the bar. And I had to kind of slow them down a bit, but they were highly dedicated. And my hope is that for them, is that by getting to know family court judges, getting to know judges who sit in Supreme Court, Kings County, they too might be inspired to become more closely aligned with the court system in New York State. As you know, a lot of associates in big firms have a federal court orientation, and they think district court, Second Circuit, want to go to the U.S. Attorney's Office. And I have, for the last 20 years, really tried to remind associates that there's, if you're a New York lawyer, the New York State court system is the busiest and most complex in the entire country. And there are a lot of opportunities to practice law or have a career in public service as part of the New York State court system.
Absolutely. Well, thank you. Your obviously your interest in mentoring comes through in all of your conversations, and we feel the same way, obviously, that we're introducing folks to different parts of the courts. I wonder, you mentioned earlier that you were finding your voice around the racial issues, which was the purpose of the report. One of the areas that you talked about is how generally over the past few years, there have been a lot of private bias, or bias that has historically been private, has sort of emerged into the public space. So the presence of phone cameras everywhere, for example, has brought us the incident of the Central Park bird watcher. It's brought us marches by neo-Nazis, and of course brought us the horrible death of George Floyd, to name only very few of the images we've seen out there. So just as you were beginning your investigation, among all those other things you were thinking about and the process you were going through to find your own voice, you looked at what the report itself calls vile racist Facebook posting by one particular court officer, which became public. So that was part of your inquiry. You looked into the community of court officers and the culture there. And I would say for those, and I'm sure you discovered this and your associates in their research, but those listening who are unfamiliar with the family courts, in those courts, court officers manage the courts. So the court officers are the people who manage the waiting area. They bring the litigants into the courtrooms. They handle documents between attorneys and judges. So for the litigants, they are really the most, the face of the family court oftentimes for them. And I wonder if you could talk a little bit about how, as a Black man, as a former member of law enforcement, how you might imagine having people with such strong racist views privately, controlling literal access to the room in which justice is supposed to be delivered, how that might impact the experience of clients like ours.
The court officer, well, the other reason the chief judge asked me to do this is because of that Facebook posting. I think that was George Floyd was the broader context, but that was the immediate catalyst. That Facebook posting, which was horrible, it's reprinted in the report, showed Barack Obama in a noose and Hillary Clinton being led to the gallows. And it was posted by a court officer in Brooklyn. So that was the immediate catalyst for her asking me to do this. And I think she asked me to do it the day that the posting became public. And so the court officer community was very much a centerpiece of the report and the review we did. The court officer community itself is a fairly diverse community, which makes for a lot of tension within that community. The Black court officers we spoke to were very outspoken about the problems they saw and about a lot of the racial intolerance they encountered among their white colleagues. They noted over and over again that the president of the union, the court officers union, has been president of that union for 46 years. He became president when I was still in high school. And so that was very much part of the tone of why we got involved in this. And you're right, you're absolutely correct. In family court, criminal court, the court officer for the litigant is the predominant presence. It's the court officer is the first person you encounter. He's a law enforcement officer with a gun. And so is in a position to make the biggest impression on a very vulnerable, unsophisticated litigant who very often speaks English as a second language. The judge makes less of impression. The court officer makes the predominant impression. And so a lot of the recommendations we made were really directed at trying to address some of the intolerance that exists in the court officer community. And a lot of, I will say this, I mean, like so many things, it's not a homogeneic culture. There are many court officers, including court officers of color, who've been in that system for decades, who are very dedicated, they're very proud of their work, and we're very pleased, I think, with some of the recommendations that we did make. But the court officer community was definitely front and center in our minds in doing this review. The other thing I'll say, the report was a reminder for me of the fact that, in my opinion, and I said this 18 years ago when I was assessing judges, when I was evaluating judges, family court judgeships and housing court judgeships are the most difficult judgeships in New York. And I include within that United States Court of Appeals with the Second Circuit, New York State Court of Appeals, because you have to make these extraordinarily difficult decisions that are high stakes for the people who appear before you with little or no help or resources, with hundreds of cases on your docket. You have to make a decision about whether to take a child away from her parent or take a person away from his or her home. And very often the evidence is not crystal clear. And these are extraordinarily difficult decisions. And you don't have lawyers on both sides arguing case law. Very often one of the litigants is pro se, and so those are the most difficult judgeships in New York, without a doubt.
I would agree with you. I mean, the decisions they make are certainly life-defining, reality-defining for the litigants in front of them. And as you said, they're consistently under-resourced. The information they have to go on is not always good. And I think you make reference to that in the report. You make, to me, what I thought was a really rare and kind of brave observation, honestly, that the under-resourcing, the consistent under-resourcing of a system that disproportionately helps people of color is inherently racist. It's going to have a disparate impact on the people who are appearing in front of that court. And
actually, the sad fact is Franklin H. Williams, a distinguished lawyer and diplomat 30 years ago, undertook a near identical investigation and came up with near identical conclusions about there being a two systems of justice in New York State.
Absolutely. And that is, that can feel a bit disheartening, honestly. I will say that when President-elect Biden and Vice President-elect Harris made their speeches last weekend, both of them from the stage talked about wanting to address systemic racism from the White House, which was, that moment was powerful in a lot of ways, but that really was a powerful moment for me, and I'm sure for a lot of people. And I wonder, as you say, your own findings were unfortunately quite similar to the findings of the report in 1991. Why do you think that barrier is so particularly hard? And what can we do to make sure that should the chief judge in 2049 commission another report, that we won't have the same findings?
Good question. We seem to make progress toward a more perfect union every once in a while, and then we seem to take 2 or 3 steps backward. 2008 election night, 12 years ago, I'll never forget being in Chicago in the park. I was very active for Barack Obama's campaign, and it was such an incredible moment. And I remember all of the emails I got, many of whom were from my law partners at Paul Weiss, about how happy they were, partners overseas. I've decided to go ahead with my application to be a citizen for the United States, and so forth. The level of pride, and we take a giant step forward, and then very often we take huge leaps backward. So I'd like to think that there's a steady arc moving in the right direction toward progress. Sometimes when you live day to day, it's hard to see that. It's hard to see that we're moving in the right direction. But I believe that overall we are. If you look at the report that we issued, there are a lot of charts and graphs in there. about the diversity of the New York State judiciary. And the charts reflect steady progress to a more diverse bench in New York State. I think the moral of that story is, as groups obtain more political power and influence, there's more diversity in their judiciary. So if you look at a comparison of Blacks in the judiciary compared to Blacks in New York State, the population has, over the last 30 years, been largely consistent, flat, and the Black judiciary has grown over time to the point where it is almost on par with the population as a whole. But then when you look at the Latinx population and the Asian population in New York State, those are steadily growing, and the judiciary is only now beginning to catch up with them. And at some point, they too will be near on par the population of the state, but it's slow and steady progress.
And for, as you said earlier on, your mandate was really to make recommendations that the court system could on its own implement, because as you make, one of the points you make in the report, this is a system that's under-resourced. The chief judge can do many things, but she can't clap her hands and make money fall from the sky, unfortunately. So it demands partnership and collaboration with other sectors of government. But you do say that, in your introduction in the executive summary, that it does demand leadership from the top, and it demands a real rededication to change, referencing the fact that, the same report done before found similar results. So what would a rededication to change from the court system itself look like for you?
Very often the leaders at the top set the tone. People do listen, whether you're talking about the chief judge of New York State or the president of the United States. Those with the largest microphone can set the tone. They do set the tone. People listen to their leaders. And if the message from the top is there is zero tolerance for racial bias, people will get that. It will have an influence on behavior and an influence on the commitment of those at the district level, appellate division level, borough, to want to see change themselves. And so that's what I meant by that. But you're correct. I felt strongly that the recommendations we make should be very specific, very tangible, and very practical, so that they can be implemented successfully, as opposed to some lofty recommendation like eradicate intolerance. Go out and eradicate intolerance. The role of somebody who's asked to do a report like this is to come up with very specific things. So that one recommendation, zero tolerance for racial, that was probably the most quantitative of the recommendations we made, but I think the chief judge understood what I was saying. And
Absolutely.
She in fact already issued such a statement.
Right, and I was struck by the breadth of the recommendation. So yes, they're all practical things that the court can own, but it can be from zero
and do
tolerance
on their own without the legislature. Right.
Right. And that zero tolerance at the top, but it also is improving signage within the court buildings, right? So there's sort of the large scale and what seems minor, but is again similar to the point that, for litigants, court officers to them are the most powerful people in the court building, judges aside. Inability to find the courtroom is a really pretty basic mandate. And for many of unrepresented litigants in particular, as you said, for whom English may not be a first language, that very minor piece can make an enormous difference in terms of litigants feeling like this is the place they're supposed to be. This is a place that's welcoming them to seek justice. And so I wonder, thinking back again to the folks that we represent, so these litigants, women of color living in poverty in New York City, for them to see that change. So I think I completely agree with you. Tone from the top is important. The chief judge has made that statement and we really welcome that. What would it take? What sorts of changes do you think would make our litigants see that commitment is, that they can see a follow through, that they can see that commitment? Because I think you mentioned in the report as well that, and we all know this generally, we have to earn our credibility and we have to walk the walk if people are going to believe that change is happening. So I think those of us who are partnering with the courts recognize the commitment from the leaders. what could the litigants that we're working with perhaps see such that they can see progress happening within that court system?
This is my wife. Hi. See you later.
Hi, wife.
Okay. 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 All right. One of the this might not be completely obvious from the report, but I think the single thing that most litigants in these courts find the most difficult to deal with are the delays, the time it takes to get from A to Z. I heard over and over again from lawyers that the client would come in, they'd be told to be there at 9:30. They have to go through the screening, and they sit around all day and wait, and the case is not called, or the case is called. It's a 5-minute appearance, and then they're told to come back in 6 months, to the point where they lose heart or they lose respect for the system, and they might even stop showing up. And so a more efficient system where people they feel like their time is valued, and because you're talking about people who have kids, who have to figure out a way to get off from work, who have to figure out their childcare situation, only to come in and sit around all day. It conveys to them a complete lack of respect for their dignity, for their time. And that was probably, if we could simply address that, start with that, that would go a very long way. But the point of the report is a lot of these things are facially very generic, but they do have a disparate impact on people of color. The courts we're talking about here, the litigants are 80 to 90% people of color. And that was the elephant in the room for me. And that's the thing that I knew the chief judge couldn't address by herself because she can't print money. But I couldn't avoid addressing it. And the leadership is right that they're in an awkward spot in that they have to depend upon the governor and the legislature for funding, and municipalities, New York City, are their landlords. The courthouses are not owned by the state court system. They're owned by New York City. They're owned by the city of Poughkeepsie. They're owned by the city of Albany. And so the state court system depends upon the New York City Council and the mayor to fix the elevators in their buildings, which is absurd when you think about it. Imagine if the federal judiciary had to depend upon Bill de Blasio for a larger court space. So that's the awkward position they're in by virtue of our Constitution. And it's one of the many, many complexities of the state court system. And very few people can understand how it got there.
Yeah, even lawyers, we're all puzzled. But I really appreciate that point, and thank you for highlighting it, because you did mention, I think sometimes as attorneys representing folks in these cases, we see the constant adjournments, right? So we know the harm that's causing our clients. So as you said, our clients are women, most of them are mothers. They're having to take off time from work that they can't get easily. They're having to figure out childcare. They're having, in the before times, traveling across town to get to the courthouse, only to find that not much is going to happen and they're going to do that again in 6 months. Also, in the family courts, typically the women in those courts are in the position of being a petitioner. So in other words, they're asking for a remedy. They're asking for custody and visitation. They're asking for child support to help raise their kids, or they're asking for an order of protection to stay safe from abuse. So, the famous quote, right, justice delayed is justice denied, starts to feel that way for a lot of our litigants, because delay is that much more harmful. And again, because they're women of color, you can't not see that disparate impact. So I really did appreciate that connecting of the dots in the report, which is that these facially neutral problems that are operational and therefore seem minimal have a significant real life implication and a racially disparate implication. I wondered if there were any other places where you saw sort of racial bias and gender bias possibly traveling together as you were doing your investigation, because we often feel, for our clients, unfortunately, they get the short end of the stick in two different ways.
Yes. One of the things that I think I didn't really fully anticipate and I'm talking about lawyers now, not litigants, the number of lawyers, women, lawyers of color, women lawyers of color who would walk into court and be mistaken for someone other than who they are. And we're told you can't sit in the front row, those are for lawyers, or their credibility is questioned if you have a female litigant of color and a female lawyer of color. Somehow they get less respect from the judge. I heard that over and over again. The district attorney of Bronx County has been mistaken for someone other than who she is in court. And I was surprised at how pervasive that still is in this day and age. One point I should mention that I think is an important point. I give the chief judge a lot of credit for calling for this review in the first place from an outsider. You know, those of us who run very large organizations don't most of the time welcome outside scrutiny of our organization. You know, I'll conduct this assessment myself. You know, this is my organization. Get away. And so I give her a lot of credit for calling for a review from an outsider, because she has no control over what I'm going to say about the system, about her leadership. So I give her a lot of credit for that. We very often, most often, don't welcome outside, objective, independent scrutiny.
Absolutely.
But she did.
Yeah, it was a brave request from her, and I think your report was brave too, because it was important to bring, like I said, made these connections between what seemed like facially neutral challenges that have a disparate impact, but also challenges that are not all within the chief judge's ability to control. So, you know, as you said before, she's a bit stuck between a rock and a hard place. And I guess with that same idea, you gave recommendations for the chief judge, things that you thought she and her system could implement on their own, understanding the context in which they're in. I wonder what you think we could do. So there are lots of stakeholders to this court system. The attorneys who practice in this system, obviously the voices of our litigants are very important to us. Do you have recommendations about how we could best partner with the courts, and how we might bring our own perspectives to the courts to assist them? Because of course, we all want the same thing. We all want to eradicate racial bias from the courts. We certainly support the chief judge's excellence mandate, which is connected to what you were talking about, that these efficiencies would in fact reduce racial bias, because they would reduce some of these negative impacts on the communities of color in the courthouses. So how could we be the best partners and the best stakeholder partners to the goals and recommendations you have in this report?
Two things come to mind. One, advocate for your clients and their interests. Advocate loudly for your clients and their interests. The squeaky wheel does get the grease. I encountered a number of public interest organizations in the course of our review who advocated very loudly for their clients' interest. And then the other thing that occurs to me, encourage lawyers that work with your organization or within your organization to think about becoming judges themselves, becoming part of the system. To a lot of lawyers, particularly big firm lawyers, the New York State judiciary seems impenetrable to them. Well, I don't know how to do that, or I can't run on a ballot, or very often it's easier than you think it is. Just come to the attention of the mayor's committee or something of that nature, and or the right screening committee. I have encouraged lawyers at Paul Weiss to think about becoming state judges, and some of them are. It's less daunting and intimidating than many people think it is. So encourage people who are really committed to these issues and these client interests to become judges themselves.
And is there a role, and this is just because the way we're positioned at Her Justice, as I've said before, pro bono first, we partner with law firms, and law firms have been great allies with us in trying to lobby for policy change, structural change. Can you see a role for law firms in this kind of conversation? So obviously one role was, you and your colleagues wrote this report in the first place, but in terms of using different voices, to assist the chief judge? You mentioned in your report, you're hoping this report will assist her in making the recommendations that she hopes to make. Is there a way that law firms could assist, and ways that we could work with law firms to assist? Because that is typically how we move forward. There's so many resources and access that law firms have that our litigants don't.
I mentioned at the outset, one of the important roles that an organization like yours plays is career development for people.
Yeah.
I know a lot of lawyers who found their mission in life working with an organization like yours. I know a lot of lawyers, a lot of associates who started off at a place like Paul Weiss, doing internal investigations and securities litigation, who found their purpose in life, in a career, working with an organization like yours, and had become part of civil and criminal justice in New York State and in places like DOJ. One of the things that's interesting when you talk to a lot of people in the New York State judiciary, including the judges, they feel as though lawyers in big law are, in another universe. We've got all these screening committees are stacked with lawyers from big white shoe firms. I think, really? They are? So among the state judiciary, very often, perhaps most often, they view lawyers from big firms as aloof, as detached, as not understanding day-to-day what goes on in criminal and civil justice in New York State. And there's a lot to that, frankly. Most lawyers in big firms never spend 10 minutes in the highest volume courts in New York State, let alone even understand them. Most lawyers in big law firms never go to criminal court, Kings County, or family court, Bronx County. And so I think the more that we as a bar can become fully absorbed and fully integrated into criminal and civil justice in this state, actually your state, I'm sitting over here in New Jersey, the better off we are as a community, as a profession.
Well, thank you. And we certainly find that, as I at the beginning of the interview said, when I talk to volunteers who work with us, they're often really surprised. They're excellent attorneys. We've trained them well, but they're often really surprised and impacted by that first appearance in family court or Supreme Court. And I like to think that they then, of course, take that experience back with them. And I've met folks who volunteered with us who 15, 20 years into their practice still remember that court appearance. They remember what they were wearing. They remember how that went. And not only is that great in terms of their own career development, but I'd like to think that it helps in terms of working with the courts to make that policy shift, because we sometimes feel that, we're working in the shadows in these huge volume courts, and the court system themselves are managing these huge volume courts. But people sitting at the law firms, just because of the different kind of job that they do, are unaware of what's happening there. So we like to think that our pro bono model shines a little bit of light in there and gets folks who are maybe sitting on those blue panel commissions or are, thought partners with the court system a little bit more aware of what's happening in these high volume courts. I guess I would just love to go back a little bit to the beginning and say, because this was a report on racial bias, was there anything you will take away from having done this investigation, and whatever it is you learned and what you it sounds like it came at an important moment for you personally, conducting this investigation. What was the most memorable piece of this investigation that you're going to take with you in whatever journey you take next?
We're still a work in progress when it comes to racial justice in even a place as sophisticated as New York State. We're still a work in progress. Considerable progress has been made, but there's a lot more to be done. And I guess the thing that I take away first and foremost, we do seem to have two systems of justice in New York State. There are the courts that are well resourced. The issues are, commercial in nature. The lawyering is sophisticated. The judging is sophisticated. But most people who interact with the court system in New York City, in particular, are people of color, and their interaction is with family court, housing court, civil court, and criminal court. That's where the action is, and those courts are woefully under-financed, under-resourced, and overwhelmed. That was true 30 years ago, and it's still true.
Well, thank you so much. That pretty much sums it up, Secretary Johnson. And we are excited to partner at Her Justice with the courts and anyone else to make sure that is not true 30 years from now. We will make sure that that arc bends in the right direction, and we will get there. So I want to thank you again so much for joining us today.
My pleasure.
This conversation will be posted soon on the Her Justice website, along with the report that you issued, so folks can take a look at all those great charts and graphs for themselves. To the audience, we're looking forward to continuing this series. Our next Justice Talk is a conversation with victims' rights attorney Carrie Goldberg on how the pandemic has increased risks of tech abuse, since we're all living in a virtual world now. And that's going to be on Thursday, November 19th at 1 p.m. And information can be found there, found on our website about that Justice Talk as well. So thank you again, Secretary Johnson, and be well, stay safe.
Thank you. Thanks for having me.
Thank you.